Now, are you aware that the autopsy doctor, Dr. McFeely, testified that she would have been unable, if there was pre-existing injury with the gun being put in the mouth, that the injury from this gun that did not have an exit wound would have obscured any pre-existing injury if there was injury as someone put it in Tara's mouth?
If the injury was to the back of the mouth, in the same area as the entry wound, of course.
Right. Now, you had indicated that Benadryl reacts differently for different people, and some people can be very sleepy, some people not so sleepy. Would it affect how sleepy they would be if you were told that she was up for 24 to 36 hours previously before taking the Benadryl?
I'd say she's probably pretty sleepy.
Now, you did indicate, your 3 studies that you did that they talked about in direct, those were with revolvers, correct?
The article that was published, yes, that was dealing solely with revolvers.
And this is obviously a semi-automatic weapon where a slide comes back forcefully when a bullet is fired. You're aware of that?
Yes.
And you're also aware that holding it upside down, there were no injuries to her hand?
Correct.
And when you were doing those examinations for the revolver study, you actually worked with a gun expert, is that correct?
That's correct.
And when you were making your opinion today about how the gun was held and that it was a suicide, you weren't working with any gun experts on this case, were you?
Correct.
And were you aware that on this gun, the defendant's DNA was on the gun, and there was a mixture of DNA on the gun between Tara and the defendant? Were you aware that the DNA expert said that although she tried not to get any blood in her DNA sample, she cannot account that perhaps Tara's blood is on the gun, her DNA is on the gun because of the blood, not her separate DNA? Were you aware of that?
Objection to the form of the question and bench conference.
So were you aware that DNA expert said that she could not be sure that the blood on the gun, the DNA on the gun was not from Tara's blood.
Objection, mischaracterizes the evidence.
Now, you're in agreement that death was instantaneous in this case, right, doctor?
Correct.
The brainstem was severed?
Correct.
So, Ms. Chavez wouldn't have been able to have any voluntary movement after the gun was fired?
Correct.
So, she wouldn't be able to put any direct pressure on a magazine release to release a magazine on a semi-automatic?
No.
After the gun was fired?
If that's the mechanism, it would have had to have occurred because of the recoil and her hitting the thumb, much like the revolver study I did.
Except there's no evidence that that happened in this case.
Same objection.
Well, he's talking about a revolver. This is a semi-automatic. Hold on. I understand in your revolver study that was the case. In this case, are you aware that both the defense's gun expert, who did an experiment on the stand to try to make that happen...
Hold on, that is also mischaracterizing the evidence. I never asked Mr. Wetley to demonstrate...
I'm not talking about Mr. Wetley.
I never asked Mr. McCann to demonstrate it.
Mr. McCann did a demonstration on the stand that didn't work.
No,
to show that the magazine could be released.
That's mischaracterizing the evidence. All right.
Judge, do you want me to step out or stay here? Okay.
Judge, I was hoping to make this thing go smoothly because Dr. Wetley's got a plane he's got to catch. But a newspaper reporter wrote an article that Mr. McCann attempted to do the demonstration of how the magazine was released in front of the jury and it flopped. That's not anything that was ever attempted. I never said, okay, Mr. McCann, now do it for us. Show us how this was done. I never did that. What I did ask him to do was show the mechanism by which it could occur. Obviously, I wouldn't ask him to replicate it because you don't have bare fingers. You have gloves on that stick to the trigger and the trigger guard. You don't have an explosive missile firing that causes the gun to rotate when upside down, counterclockwise into the thumb. You don't have any of the conditions. In fact, counsel for the state, Mr. McKay, went over that with Mr. McCann, that you obviously couldn't have a gun pointing at yourself, and you obviously had to have a finger, but you could show that it would be done. And now in court, without firing the gun, you can show how it would be done, but obviously you couldn't replicate the conditions. I never asked him to make a demonstration of how it occurred, because if I had asked him to do that, he would have had to have shot a live round, because part of the mechanism, as he described, was the recoil causing the magazine release button to be pushed into her thumb. I never asked him. That's the product of the imagination of a newspaper reporter, and it never happened. But again, counsel should not be allowed to mischaracterize evidence to this witness, just like Mr. McKay did last week to Mr. McCann, and use a witness basically as a dartboard for bringing out mischaracterized evidence, for weakening the evidence for example, of their DNA expert, they've got a big problem that Tara's DNA is on the gun where there was no blood, because they're saying that the gun wasn't in the house and Tara, didn't kill herself. So when the state makes these sort of mischaracterizations, they're only using the witness as a foil to undermine their own earlier witnesses. Getting back to this immediate point here, first of all, Ms. Keener wasn't even here Friday. Maybe she picked up a newspaper and that's where she's getting her cross-examination material from. But she wasn't even here when Mr. McCann did that stuff. And I never said, okay, now, replicate what happened. Never ever did, other than having him go in front of the jury and explain that when fired, it rotates and how it pushes the thumb into the button. So I object and would ask the court to inform the jury that they are to disregard those questions coming from Ms. Keener.
And Your Honor, obviously, I'll deal with what was on, and it was obviously Wednesday, not Friday. And clearly, while I don't remember if the question was from the defense counsel, the witness made it very clear that he was attempting to show how you could do in one movement the release of the trigger, and that he could not, the magazine on fire, and that some days he could do it and today he couldn't, was his testimony. So we can call it whatever we want. Whether it was asked by the defense, it was clearly he was attempting to show what he said could happen, and then he had to admit that he had never done it with that gun. That the experiments he had done was with a totally different gun, that he didn't even know what the pounds of pressure were for the release magazine. And so he was unable to show that in this gun, the gun in this case, that he could actually do a release in one motion. And I think that is a fair question to go to whether that affects this witness's opinion in this matter.
I think he says sometimes it works, sometimes it doesn't.
Yes.
I'll allow the question, but it has to be a fair question in the sense that there wasn't a live round in there.
Oh, absolutely. I would say it was a court demonstration, Your Honor.
We don't have Mr. McCann around anymore.
No. Mr. Radosevich did, in fact, though, use the actual gun with live rounds and was not able to make it work either. He used the actual gun to try to make the magazine release.
No.
Not with the live rounds, but he used the actual gun itself. He did shoot it upside down and try to make the magazine release in one action and was not able to.
Just call out the jury. And counsel, if you have to work through a lunch hour, that's fine, so we can get
Got a plane catch.
out of here.
Yeah.
Thank you.
Thank you. Dr. Whitley, were you aware that the defense expert in front of this jury with the gun, but not with live rounds, tried to manipulate it by pulling the trigger and getting the magazine release at the same time and was unable to do it?
Yes.
Were you also aware that the gun expert, Mark Radosevich, testified that he actually used this particular gun, doing it upside down, and was also unable to have a round chamber and release the magazine when it was being pulled?
I was not aware of his testimony, no.
So would either of those affect your opinion today that those would not be consistent with suicide?
No, I'd say we have to figure out how the magazine was released, if in fact it was released.
And that's what the jury's here for today. In a moment. Now, you testified that the soot on the tongue, but there wasn't any injury to the tongue, is that correct?
I couldn't tell. I saw a lot of soot and what looked like burn injury. I couldn't tell if there was a laceration in the center of that or not. Not from the photograph.
I'm a moment.
Now, the handwritten worksheet that says when it checks that the teeth are normal, or circles that the teeth are normal, and then says see injuries.
Correct.
The body of the autopsy itself describes those injuries, correct?
Actually, sorry.
I was going to say, quote, the anterior teeth are natural and in good condition apart from the maxillary and mandibular injuries described below.
Correct.
Okay. And so teeth can get fractured as a result of cheekbone or jaw injuries?
Yes, they can get various injuries with the fractures of the jaw, yes. Upper and lower jaw, yes.
All right. And so you were quoted a piece of information from a Dr. Zumwalt, and I just wanted you to have the benefit of the entire response, where the question was as to whether there was any damage to the teeth done otherwise, and the answer was yes. This shows a chipped tooth, and it also shows fractures in the jaw. You can kind of see the space between the teeth where it is fractured. I mean, when you get such an expansion of gas in the mouth, it is going to break. It is not uncommon. Would you agree with that statement?
Yes.
Okay. And so when Dr. Zumwalt was referring to the injuries, he was again referring to the injuries as having been caused by expansion of the gas in the mouth.
That's how I interpret that, yes.
Now, let me show you a couple of things. Someone can have jaw fractures that are quite anterior, quite close to the, from an intraoral gunshot wound, Fractures can be...
Objection, bleeding.
Raise the question.
All right. Can fractures be caused by an intraoral gunshot wound? Fractures of the jaw occur near the anterior part of the jawbone, the front, where you would see the teeth, as opposed to in the back?
It's certainly possible, yes.
Okay, all right. And I think you indicated that you could not be certain whether there was a... I need to take this out. You couldn't be certain whether that's evidence of a chipped tooth or not.
I'm not convinced that it is. It looks
Yeah.
intact. There's some irregularity there, but I don't know what it is. Again, when you have the cleaned up, when you can have the advantage of having it cleaned up and photographed and examined in the situation of the morgue, you can be more definite about it.
In the morgue.
Scene examination is frequently limited because of poor lighting and many other things.
All right. And as to whether or not there is a chipped tooth, that's, I guess, something about which reasonable minds can differ?
I would think so.
Okay.
Well, it's based on this photograph, yes.
Based on that photograph, right?
Correct.
Thank you. But there's nothing that I got to tell you that you are in company with Dr. McFeely, who said there's a possibility of a potential for a chipped tooth in the lower incisor. Okay. So now let me show you something else. Going back to Defendant's Exhibit II. The injuries caused by the gunshot wound, the deposit of the flame coming out of the muzzle, the unexpended, perhaps explosive gases, etc., are all present far back, the posterior of the tongue, right?
Correct.
Okay. And so if there were any injuries that, if someone were to say that there could be inflicted injuries, but that they would be obscured by the injury from the gunshot wound, that is, to the inside of the mouth, then any obscuring would have to happen back here where the gunshot wound occurred, right?
Correct.
Okay. And that would not prevent the, or would it? Would it or would it not? I'm referring to somebody shoving a gun in the mouth, into Tara's mouth. If Tara had resisted, would you expect to find injuries closer in as the gun was being inserted before it made its way to the back?
Yeah, I would expect to find injuries to the lips, the anterior teeth, as well as to the anterior or front portion of the tongue.
Okay.
Exactly.
So you'd see something there, is what I hear you telling me, if somebody had shoved a gun into her mouth.
I would expect to if she's resisting, yes.
Okay. And the front of the tongue, any injuries that would be to the front of the tongue would not be obscured by the gunshot wound, because that's not where it happened. The wound happened, right?
Correct.
Okay. And so that leads you to your ultimate conclusion that the manner in death in this case was a suicide?
Correct.
Thank you.
Doctor, you may be excused.
Thank you.
Judge, we have a witness, but not coming till 1:30. There's a couple of matters we can deal with, though, without the jury.
Okay, let's do this, folks, let's recess until here about 1 o'clock, 1:15, and we'll get started thereafter, okay?
All right.
Sure. Does he need to get going right away?
Yeah.
Let's wait for the jury to go.
Maybe seated. This way, good. Before I forget, Mr. McKay, can I get a copy of your jury instructions?
I've only got one copy. I printed them, but I haven't had a chance to go down and copy them. I'll
Can
get
you
them.
give me some, before we start this
Yeah, yeah,
afternoon?
so when I go down for lunch, I was planning on like I said, I
Right.
printed them out, but I only have the one at this point, so.
Judge, we filed a motion, yesterday, and I've given copies to counsel, and I'll give the court a courtesy copy of my motion and my request for setting in the notice of hearing, and, that is my motion to exclude the testimony of Dr. Roll as a rebuttal witness, but,
I can make this fast, Your Honor, we're not gonna call Dr. Roll.
Okay.
and that's all I wanted. I wanted to put the
Decide it.
record him to
Decide
say
it.
that.
Okay, you want the motion.
Okay, that's good.
Okay, that's good. Okay. Anything else?
I don't think so, Your Honor.
Nothing, Your Honor, so I'll get you copies
Mr.
of
Arnott,
those.
if you, I think the jury instructions should be pretty straightforward, but
Right.
if you have any that
I may have some.
just get them to me as well.
So obviously, I'll get both Mr. Turner and yourself copies after lunch, Your
Oh,
Honor,
yeah,
that's what I
that'll
plan
be
on
fine.
doing, so.
And be here around 1:10 or something.
Okay.
Okay,
Okay.
we'll be in recess.
All rise.